consider today rehabilitation, punishment, protection, and deterrence. My goal is to impose a sentence that is reasonable. A reasonable sentence is one that's proportionate to the seriousness of the circumstances surrounding you and this offense. That I am going to consider all of those factors today. You come before the court anchoring your criminality in addiction. I'll give you that addiction is compelling, at times all-consuming, and even deadly. I believe that time you are capable of rehabilitation, and I am taking that into account today. But there are other factors at play as well. As noted, punishment, protection, and deterrence are important. Your job was to protect and to serve. You blew that up and instead involved yourself in the very activity you were called upon to do. How can we ask that of others when we don't require it in ourselves? You chose this job. It's a stressful one, more stressful than any other job I can imagine. It's supposed to be selfless. You put the lives and well-being of others above yourself. The reverberations from what you did will carry on long after what you did. Well-meaning law enforcement who do protect and serve will now be criticized and second-guessed, not because of what they did, but because of what you did. The integrity of criminal cases, as well as Hartford PD and other agencies, will now undoubtedly be put in question, again, because of your actions. To say that you abused the authority entrusted in you is an understatement. To the extent your addiction fueled you, you had options. First option is to leave your job, one in which the public entrusted you to reduce crime and deal with your health issue. Instead, you married the two concepts and used your status not only as law enforcement, but chief. You're the leader of law enforcement. Use that status as recruitment for controlled substances. A strong sentence today will hopefully not only punish you and protect others from you, but also deter others, although a small group I presume, who choose public service positions to turn around and abuse every oath they took to serve. As I've noted, the guidelines are a tool for this court, as advisory as they are. Considering all the factors I am to consider today, I agree with the Attorney General that a sentence at the top of the advisory guideline range is appropriate, fair, and proportionate. On count one, I'll sentence you to 330 days in jail. You have credit for 1 day served. This is to run concurrent to count two. I do recognize that that is a presumptive no jail count, but I believe for the reasons I've noted, there are sufficient, more than sufficient, reasonable grounds to propose that sentence. $68 in state costs is ordered. In count two, I'm sentencing you to 40 months to 20 years with the Michigan Department of Corrections. You have credit for 1 day served, crime victim assessment of $130, DNA testing fee of $60, $68 in state costs. You do have a right to ask the Court of Appeals to review the conviction and sentence. You have a right to ask for a court-appointed attorney to assist you in that review if you're financially unable to afford your own. If you do wish to make the request, you'll need to fill out the paperwork we're handing you today and turn it back into the court within 42 days on today's date. Bond is canceled. Council, we're discussing 3 through 9, is that correct?
Yes, Your Honor.
Okay, those will be dismissed. Anything else, Council, I've neglected?
No. Could you repeat so I understand? There's your sentence on count one. I apologize that I didn't hear it.
Count one is the 330-day credit for one. And that may be served in any correctional facility.
Thank you for that clarification.
Council, is there, as part of this agreement, was there, I thought I recall, was there objection to SAI?
Yes,